All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
All right. Everybody good this morning? All right. Madam Clerk, if you'll call the case, please.
Case number SC 2024-0857, Grant A. Banks v. Shannon P. Banks, individually and as personal representative of the Estate of Raymond L. Banks and trustee of the Banks Family Trust. It's an appeal from Winston Circuit Court. Arguing for the appellant, the Honorable Chris Hamer, and arguing for the appellee, the Honorable Chip Browder.
Counselor, are you ready?
Thank you, Madam Chief Justice, and may it please the court. The case before the court this morning is unprecedented. It raises serious concerns about the rule of law and the rights of beneficiaries. We are here today because Grant Banks, a 19-year-old beneficiary, was declared to have forfeited his inheritance, not because he contested the will, not because he challenged its dispositions or sought to alter its effect, but because he sought to enforce his rights under Alabama law and the will to seek an inventory and an accounting of an estate and trust.
Wasn't one of the terms impede the administration of the trust, of the will, the administration of the will?
Yes, Justice Wise. One of the terms of the forfeiture provision was to impede the administration.
Okay, thank you.
In this case, the Winston County Circuit Court stayed proceedings, and it delegated its judicial authority to an advisory committee to decide the most serious issue and one of the most draconian remedies that can result: forfeiture of inheritance. That abdication of judicial function was based on a provision in a will that purports to divest the courts of jurisdiction and requires that any claim or dispute be decided by a non-judicial advisory committee whose decision is final and not subject to judicial review.
You would agree with me that the wording of this clause in the will covered his petition for an accounting?
I would agree with you that with respect to and Justice Cook, just so I can make sure I'm clear with your question, are you referencing the advisory committee provision, or are you referencing the forfeiture provision?
I really, and you're right to ask the question, I really meant both. Both of them, his action, his guardian's actions would be within the literal terms of both of these clauses, right?
I think with respect to the forfeiture provision, I'll take that first. A strict and narrow construction of the forfeiture provision the forfeiture provision does not say that a petition to compel an inventory and accounting triggers a forfeiture. It does not say that a failure to go to the advisory committee triggers a forfeiture. Neither of those.
Is that more procedural versus substantive? Wouldn't that be your argument?
I think that the argument is one of procedural due process, but I think that the argument comes down to when this court construes a forfeiture provision, if they are enforceable in Alabama, which I'm not sure that there is any case that says that they are enforceable, but if they are enforceable, this court has to strictly construe it narrowly and can't look beyond the express terms of that forfeiture provision. That's Kershaw and that's Harrison. And that's what those cases say. Alabama law abhors a forfeiture.
Did the will provide that an accounting should be done?
Alabama law requires an accounting to be done.
That can be waived in a will. I mean, if you say there's no bond, no accounting, but I mean, did it require an accounting?
Yes, Justice Wise, it required that an inventory be provided to a beneficiary upon request at any reasonable time.
Okay, thank you.
So let me ask this question. You raised that there were two clauses at issue here. There's the, I'll just call it arbitration clause for shorthand. I'm not agreeing it's an arbitration clause, but arbitration clause and the interim clause. So if we were to agree with you that the arbitration clause could not be enforced for public policy reasons, should we reach the interim clause, or should we, because it's a legal question, or should we send that back to the trial judge and let the trial judge figure that out?
Justice Cook, I think you're correct in that you should reach the interim clause because it is a legal question. It is, respectfully, this is an issue that is likely to reoccur, and that the ultimate result of all of this, if you send it back after the advisory committee provision, is we will be right back where we started, which is a beneficiary seeking to enforce his rights under Alabama law to obtain information to ensure the proper administration of an estate and trust. And if that is a breach of the forfeiture provision, which I do not think that it is, then the end result will be a forfeiture and we will be right back here.
Why did you not appeal immediately when there was a order to send you to, again, I'll use the word arbitration?
There were two orders. Those orders stayed proceedings. The first order required the parties to take their disputes. So the parties shall take the issue of forfeiture, and I'm paraphrasing, but the issue of forfeiture to the advisory committee. The second order maintained the stay of proceedings and amended the original order and said the parties may take any dispute, including but not limited to forfeiture. Both orders stayed proceedings. They didn't resolve the issue of forfeiture. They were interlocutory orders. The court stayed proceedings and declined to rule or enter a judgment until it received the result from the advisory committee concerning forfeiture.
So it's your point that it's not a final judgment?
It's not a final order. Yes, Justice Bryan, that's correct.
What do we do about the testator's intent here? I mean, the testator put this clause in the will for some purpose. Are we just going to say, public policy wise, we're just going to ignore the testator's intent?
Testamentary freedom exists because of Alabama law, and it is limited to the extent that it conflicts with Alabama law or public policy. That is the limit of testamentary intent.
So can you waive an accounting? Can you waive an inventory? Can a testator in his will do that?
Justice Sellers, the answer to your question is yes, they can waive an inventory and accounting, but they can't waive the court's authority to order an inventory and accounting, and they can't waive a beneficiary's right to petition a beneficiary or interested party in the terms of an estate.
So then what's the purpose of the waiver? If a testator wants to put a waiver in there, you're saying that it's just limited, it makes him feel good that he puts a waiver in there? I mean, if a court can overrule, if a beneficiary can overrule it, what's the reason of having that in a will to begin with?
If a beneficiary makes out an affidavit and says that his interests are in jeopardy for want of security, that they're endangered, then the beneficiary can invoke the jurisdiction of the court in order to order an inventory and an accounting. A settlement of a decedent's estate is required, a final settlement is required irrespective of whether or not there is a provision in a will that seeks to waive it. Beneficiaries can consent to that final settlement, but absent consent, it's required. The Alabama Uniform Trust Code under a trust makes mandatory the requirement to provide information to beneficiaries about the trust, and it allows beneficiaries to petition for an accounting, and the power of the courts to order an accounting is mandatory. It cannot be waived by the terms of the trust.
So if the beneficiary doesn't consent to the final settlement, if he doesn't, can that failure to consent to that also run afoul of the interim clause?
No, Justice Sellers, I don't think that it can, because I think that the fundamental function of, be it a probate court or an equity court in terms of an estate or a trust, is to see that the assets are administered appropriately, and the only way that can occur is by the court reviewing and approving an accounting that displays the receipts and disbursements and how those funds are used or applied. So with respect to a decedent's estate, absent a consent, which beneficiary cannot challenge actions or even review actions of a trustee that might be a breach of fiduciary duty if they don't know whether or not those actions have occurred. It is impossible to redress a breach of fiduciary duty for an action the beneficiary does not know about. That's why, in order for fiduciary duties to mean anything, a beneficiary has a right to know, or at least to request information sufficient to know whether or not there's an action that needs to be challenged. With respect to the forfeiture provision, if you construe it narrowly, and you look at the actions of what Grant didn't do, he didn't contest the will, he didn't challenge dispositions, he didn't say, I want more than half of my estate. And looking at the testator's intentions, if you look at his intentions, you read the will, and you look at the four corners of the will, it is abundantly apparent. He wanted his entire estate, both probate estate and non-probate assets, divided evenly between his two sons. That is his manifest intent. There's an equal division and advancement provision that is nearly a page and a half that talks about, I want this evenly divided between my two sons. Grant didn't challenge that. He didn't dispute that. He didn't say, I want more than my brother. That's not what he did. He asked for an inventory and accounting. If you look at the express terms of the forfeiture provision, it does not prohibit that. He sought redress from the court based off of statutory rights provided to him under Alabama law. And he did that so that he could obtain information to determine whether or not a breach of fiduciary duty had occurred. Maybe it hasn't. Maybe it has. We will never know if he does not get that information. And it's information he has a right and he is entitled to.
I'm sorry. At some point, wasn't there an agreement to provide the information, to provide additional information beyond the terms of the will?
There was,
There was a meeting,
Justice-wise, I'll
agreement.
answer your question in saying, no, there was never an agreement to provide the information. There was the acknowledgement that additional information existed and was out there, and a requirement that a confidentiality provision be executed, and limitations on how the information could be used or disclosed, and for what purpose.
So there was a proffer to provide this additional information that was requested.
There was a proffer to provide information. There's a difference between information and a formal accounting or an inventory. And what information was being offered, justice-wise, I will say I cannot tell you because I never received it, and neither did Grant.
And that was because your client refused to sign the confidentiality agreement. Is that why it was not provided? And you may not be able to answer that. I'll ask them. They might be able to provide that information.
Justice-wise, we never received a copy of a confidentiality agreement. And so to answer your question, we can't sign something we haven't received.
Thank you.
I'm sorry, I see my time.
Yeah, your time is up. Madam Clerk, if you'll take the time that he went over and add it to the Appellee's time, please. All right, are y'all ready?
Madam Chief Justice, Associate Justices, may it please this honorable court. 4 years, 200 years, and the number 9. For 4 years since the death of their father, Rusty Banks, from complications of COVID. For 4 years, this estate has been in and out of various courtrooms. For 4 years, baseless allegations, unsubstantiated claims of wrongdoing, and not a single shred of evidence of any wrongdoing. 4 years of senseless and pointless litigation. 4 years of litigating rather than cooperating.
Okay, Counselor, I get the term 4 years, but who appointed the guardian ad litem for Grant?
Well, thank you, Mr. Justice Brown. The probate court initially appointed guardian ad litem Shane James when the will was being probated.
Grant didn't appoint a guardian ad litem for himself.
No, sir, the probate court appointed the guardian.
A guardian ad litem is the one that decided that I'm going to ask for an accounting, right?
I would say the guardian ad litem joined in that request.
With whom?
With counsel for Grant Banks, Mr. Hamer.
Right.
I would ask, we provided the court with our exhibit as a timeline, and I'd refer the court to the exhibit August the 15th of 2022. There were a couple of questions as far as information having been provided. In August of 2022, the IRS Form 706, which is a detailed and thorough accounting and inventory of assets and liabilities of this estate. It consisted of approximately 250 pages. It included tax returns for the decedent. All that information was provided to the guardian ad litem, who in turn provided to Mr. Hamer, again, August of 2022. There have been several questions regarding the information, the additional information that had been requested. That information was gathered. There was a verbal agreement reached in August of 2023, Madam Justice Wise. And the agreement was to provide this additional documentation, which consisted of business records of the various family businesses in which the estate owned an interest, tax returns, and bank statements.
And at that time, Grant Banks was still a minor, right?
Yes, Mr. Justice.
He was still represented by a guardian, right?
Both the guardian ad litem and Mr. Hamer were both in that meeting in August of 2023 when the verbal agreement was reached to turn the information over. Basically, to open.
But Grant Banks was not in that meeting.
No, sir, he was not.
And
Minor did not have participation in that meeting, did not maybe know of that meeting, this Grant.
Excuse me. We have to assume that his guardian ad litem and Mr. Hamer informed him of the meeting and the verbal agreement that had been reached. The understanding among counsel and with Shannon Banks, the executor, the older brother, was in that meeting. And the agreement was that the books would be open to Grant and his counsel. Any questions would be fully answered, provided the information that was being provided would be maintained in strictest confidence and not disseminated. That was the understanding. When it came time to provide a written confidentiality agreement, counsel for Grant, Mr. Hamer, presented what I'd refer to as a litigation confidentiality agreement. That agreement did not conform with the verbal understanding. And contrary to Mr. Hamer's comments a few minutes ago, a revised confidentiality agreement was provided to Mr. Hamer at that time. We never got any feedback from our submission of a revised confidentiality agreement.
so let me jump topics slightly and
Yes,
stay on the interim clause. So you agree with me that in Alabama, we've never actually enforced one, right?
I respectfully disagree, Justice Cook. The 1881 case of Donegan versus Wade clearly established that would be the seminal case in Alabama dealing with forfeiture clauses in territory.
It indicated it was possible. It didn't actually enforce one, though, right?
No, respectfully, the clause was enforced. And forgive my old, more gray and failing memory, I don't remember if it was a sister or a brother that brought the contest. And once they realized that they were tripping over that forfeiture wire, they attempted to withdraw the contest. And the court held, based on the express language in the testator's will, that the mere filing of that contest triggered the forfeiture, and them agreeing to withdraw it, it was too late. So that forfeiture clause was upheld in that case.
So-
I'm sorry, go on.
No. I was just going to stay on the set of questions here. So you're unaware of us ever enforcing an interim clause for the filing or request of an accounting, right?
No, sir, and that is not the trigger in this particular case. The grant requested an accounting was not why the advisory committee rendered their
So
recommendation.
what was the trigger?
I would point out that Grant didn't request it. It was the guardian ad litem that requested it, right?
The petition that was filed in March of 2024, again, approximately a year after we had reached the verbal agreement to provide this information, 2 bankers' boxes of information were actually brought to the trial court at that time of that March, I think it was March 5th hearing. The petition for an accounting was actually filed by Mr. Hamer on behalf of Grant, even though he was still represented by guardian ad litem at the time.
So back to my question, though, if it wasn't the accounting, the request for the accounting that triggered the disinheritance, what was the trigger?
Thank you. Mr. Banks' will specifically said any dispute, and obviously he anticipated this, unfortunately, but any dispute was to be resolved among the brothers, if amicably if possible. If not, he prescribed that the dispute would be taken to this advisory committee and settled out of the public eye, if you will. There's 200 years of precedent, starting as early as 1832, where this court in Maddox versus Hartley declared that the right of property was a.
What's the trigger
Oh,
other than the filing of the accounting?
yes, sir. The initial filing in August of 2022 was a filing for statutory exemptions and allowances. Mr. Hamer spoke on that earlier. If a close reading of 43, 8, 110, 111, and 112 state that those statutory exemption and allowances may be requested unless the will provides otherwise. And at the bottom page 690, in the clerk's record 690, at the bottom of that page, I think that's page 29 in Mr. Banks' will.
What's the trigger other than the accounting?
That's the initial trigger, yes, sir. And because the will stated that any benefit provided for a beneficiary was in lieu of any and all other claims, whether statutory or otherwise. The second trigger was that same month, August of 2022, when pursuant to the terms of the will, Shannon Banks filed for recognition as to be not recognized by the probate court as conservator over his younger brother's minor accounts. That petition was challenged. Again, Grant was 14 at the time, and he did have a right to challenge it. But that challenge of his brother's appointment was in direct contradiction to his father's instructions under the will. Now, Shannon Banks, as executor, ultimately did not take that dispute to the advisory committee. He could have, but that dispute was ultimately settled before the probate court with the understanding that Shannon would not be put in charge, Grant's mother would not be put in charge, rather the probate court itself maintained control over those minors' accounts. But technically, that was an additional forfeiture event. Third, when the petition was filed in March of 24, I believe, for the accounting, or for the inventory and accounting, the information had already been previously provided, so basically we're asking for duplicative information. The business records, again, have been gathered in 2 banker's boxes, bank statements, tax returns, and bank statements. But those were taken to court the day before Mr. Banks filed his motion to compel an accounting and inventory. The records were gathered, were offered in January of 2024.
My question was, what was the triggering event? So you've listed requests for exemptions. You've listed the conservatorship of Grant himself, and then we're also the question of the accounting, right?
Yes, Mr. Justice.
Those three things. Those are the 3 triggers.
So do those triggers, looking at the forfeiture clause, is that what constitutes impeding the probate of this will? Because clearly there's not it doesn't appear to be a contest. So then we fall back on impeding the probate of the will.
Yes, ma'am, Madam Justice Wise, it might answer both those questions. The request for the information was not a trigger event. The trial court, as this court has charged it in Smith v. Smith back in 1908, and Montgomery, I think 1931, where this court has laid down instructions to the trial courts that you are to ascertain the testator's intentions. And I believe it was Smith that said the trial court has the power and the duty to see that the testator's intentions are carried out. So the trial court, having construed the will, obviously read the provision that several justices have referred to, is taking your dispute to the advisory committee. Y'all can't settle it among yourselves. And the court ordered that the dispute be taken to the advisory committee in June of 28, and a further clarified opinion in July of 22.
And the dispute they're taking is the accounting.
Yes, sir. But in addition, the court also said, based on the express language in the will, any dispute may be taken to the advisory committee. And so the estate raised the issue of forfeiture. Now, those were duly lawful orders. And we disagree with the previous response to your question, Justice Cook. Those were in the form of an injunction directing that certain actions be taken, determining the rights and obligations of the parties pursuant to the language in the will.
Do you think referring that to the private dispute resolution committee was an injunction?
Yes, sir. In other words, the trial court in those orders directing the parties that the dispute is to be taken to the advisory committee. As an injunction, if the opposing counsel disagreed with that court order, he had two options. He could either appeal it or seek mandamus review. He did neither. So respectfully, we don't think this honorable court should find the learned jurors below in
It'd be a
error.
preliminary injunction, right?
Pardon?
It'd be a preliminary injunction, and you get arrive an appeal for a final injunction, right?
It directed that certain action be taken, Mr. Justice
I
Wise.
think it was a final injunction.
It never was appealed. So again, the estate's position is if they had a disagreement with taking the disputes to the advisory committee, the time to have raised that would have been, as I think Justice Cook was astutely observing, way back then, not now.
So let me jump topics a little bit. Are you aware of our court ever affirming a decision to send a issue of probate to an arbitration? Has our court ever done that?
I'm not aware of an Alabama case that recognizes that. Again, there's 200 years of precedent that we've laid out in our brief, again, starting back with the Maddox decision in 1832, which recognized the testator's fundamental property right to attach conditions and restrictions on that inheritance.
Are you aware of any state in the country that has approved sending something probate matter to arbitration unless there's a specific statute allowing such a thing?
Again, I'd respectfully disagree with the use of arbitration. I would refer to this committee as umpires, that they were vested.
That's fine. I'm not trying to call it arbitration. I was trying to use a shorthand term.
Yes.
Are you aware of any state in the country that has where the appellate courts have approved sending something to a private dispute resolution committee where there's not a specific statute on point?
We've cited several cases in our brief, Mr. Justice. U.S. Supreme Court. There is a related Alabama case not dealing with a will, but again, the fundamental property right provides that a testator, a grantor, settlor, has the right to dispose of his property by deed, lifetime gift, or testament or disposition. This case in 1918, Birmingham versus Graham, dealt with a deed. And in the deed, there was an option clause in there. And it provided that if that option was executed within the 2-year time period, if the parties could not agree on the value of the purchase, then an umpire would decide that value. And it stated the decision of an umpire would be final. But there are cases in other states, again, that we've cited. Mississippi, a 1939 case, Earthley versus Wynn. 1917 case, Grant versus Stevens out of Texas. A U.S. Supreme Court case, one of the earlier cases, 1828, the Pratt case, and several others that we've cited in our brief. Now, in these cases, and the Pratt case, I don't mean to point at you, the Pratt case specifically says that the court will not substitute its judgment for that of the umpires, provided the advisory committee has not gone rogue and failed to follow the intentions of the testator.
Well, there actually is a statute in Alabama allowing a trust dispute to go to arbitration, right?
Yes, sir. But again, the trust
that was with the express consent of the parties, right?
Yes, sir. But again,
There hasn't been express consent here, right?
No, sir. But Mr. Justice Cook, this case does not involve the trust. The estate has still not been settled, and the estate has not poured over into the testamentary trust. That'd be my.
You were citing trust cases.
I believe that was probably Mr. Hamer, Mr. Justice.
Are you aware of any cases anywhere in the country that have approved sending a probate dispute to arbitration when one of the parties was a minor?
No, sir. Again,
How about if the dispute was about an accounting? Are you aware of that ever being sent to a private dispute resolution group anywhere in the country?
not that I'm aware of. Most of these cases don't
So-
spell out exactly what the dispute involved.
Right. And are you aware of an interim clause ever being enforced against a minor?
Well, in Alabama, there's only the one case in 1881 where the clause was enforced.
And so I'm talking about across the whole country, anywhere where any court has ever enforced an interim clause against a minor.
I'm not. Now, at the time that the committee was directed to consider the dispute, where the court referred the dispute to the committee, Grant had already attained majority age. He was reached majority age in, I think, October the 13th of 2024.
But all of the actions for which the committee was considering him had been done before the court when he was a minor.
That's true, but at the time, obviously, Justice Cook, he was represented by not only guardian ad litem, but private counsel.
At the time the committee submitted their report, he was no longer a minor. Is that correct?
Yes, ma'am, Madam Justice Wise.
And the committee refused to deal with his counsel, right?
Pardon?
The committee refused to notify or provide his counsel information.
I disagree with that statement respectfully. Each side had an equal opportunity to present their arguments to this committee. That's my number 9. The first opportunity was when the trial court entered its final order directing that the disputes be taken to the advisory committee.
My question is much simpler. The committee didn't give notices to his lawyer. They sent them to him directly, right?
Well, they didn't send us notices either, respectfully, Justice Cook, excuse me. But both sides were well aware of that court order. And respectfully, from our perspective, counsel for Grant Banks ignored that court order, did not appeal it, did not see mandamus review. They just ignored it.
Who is on the, I'm sure it's probably in the record, but who is on that advisory committee?
Yes, sir.
The names, or did the court select the individuals for the advisory?
I'll answer his question first, if I might, Madam. 3 local business leaders. The first, Jimmy Johnson, was longtime friend, trusted advisor of Mr. Banks, had done his tax returns for years. The other 2, Jeff Gunnan and Mr. Jared Key, I forget Mr. Key's first name. These were close business associates, friends of the testator there in the local community.
No attorneys?
No, sir.
I'm shocked.
Mr. Banks had an affliction for attorneys.
I don't care what he had. I'm shocked that it wasn't attorneys.
Yes.
Again, did the will provide for that, or did the trial court name the individuals that would serve on the committee?
Thank you, ma'am. The trust itself set up the agreement. Mr. Banks himself named Jimmy Johnson, his accountant and advisor, on the committee. The provision in the will specifically stated there would be 3 members. Mr. Banks never got around to formally naming those other 2 members. He made his accountant, Jimmy Johnson, aware of who he would put on it, but he never got back to us to do a codicil. But the will specifically says that there's a vacancy on the committee. Mr. Johnson, as the named member of the committee, had authority to appoint the other 2 members, and that's how that transpired. So for 200 years, the court has recognized the fundamental right of a testator to dispose of his property with limitations and restrictions. And I'd like to quote the Republic Iron and Steel case of this court back in 1920. Again, commenting on the fundamental property right. It says, legatees are not bound to accept the bequest, but if accepted, it must be subject to the disabilities annexed to the conditions and restrictions. It must be taken all or none. My time.
Counselor, yeah, your time is up.
Thank you for your time.
Thank you. Mr. Aaron?
Mr. Hammer, before you even get started, I've just got a question so I can get to it. Did y'all receive a copy of the Form 706?
Justice Sellers, yes, we received a copy of the handwritten 706 that created more questions than it did answers.
So what was there on the IRS form that was missing?
There was, it's not necessarily what was on the form that was missing, it was what was missing from the documentation that supports a 706. A 706,
But the form would be a summary of all these other things. So if you had that information that's there, you've got everything you need to know about a estate, it would seem like to me.
no, Justice Sellers, because the information on the form is only as good as the source documentation that supports it.
So it didn't trouble you that the form is signed under penalties of perjury, and if they had signed the form, they would be perjuring themselves if the information was not accurate?
I think the form, the information contained on the form, and the lack of supporting documentation troubled me, Justice Sellers.
Okay, thank you.
Question. Did you file a writ of mandamus after the advisory committee was appointed? I know you filed a motion to alter or amend or vacate the order in the trial court, or the guardian ad litem. Did you file a writ of mandamus with this court?
Respectfully, no, Justice Wise, we did not file a writ of mandamus. We viewed that order as an interlocutory order and waited until we received a final judgment before we filed an appeal.
Okay, thank you. Second question. There appears to be a dispute, and I don't know the truth here. There's three sides to every story: his, yours, and the truth. Apparently, counsel, you said you did not receive any type of confidentiality agreement. Opposing counsel says they did send something over. Did you just not receive it?
You're Justice Wise. I think we may be talking about using terminology to refer to a draft proposed motion for protective order, which would have provided for confidentiality, which is what I prepared and provided to Mr. Browder. There were revisions made to that. Those revisions contemplated not only terms that I believe to be inappropriate, but the further execution of a confidentiality agreement. There was no confidentiality agreement provided.
Okay, thank you.
I would like to take a few moments, well, I have a few moments, to address a few reasons why the advisory committee provision is not an arbitration provision. It denies due process. First, specific performance of a pre-dispute arbitration agreement violates Alabama statutes and public policy unless it's preempted by the FAA, and there is no FAA preemption here. Procedures employed by the advisory committee didn't provide notice, didn't provide a hearing, didn't provide disinterested, impartial neutrals. And pursuant to the terms of the advisory committee provision, the compensation of the advisory committee is determined by Shannon in his sole discretion. It does not provide for due process. Alabama's probate statute that permits arbitration and the Alabama Arbitration Act require parties to an existing controversy to consent to submit their disputes to arbitration, and Grant didn't consent. Justice Wise, with respect to your earlier question about whether or not Grant's petition for an accounting impedes the administration, administration includes all things that may rightfully be done by a beneficiary or legatee to secure their rights. Petition for inventory and accounting is not an impediment to administration. It's participating in the administration.
according to the document that's been provided to the court, there's a question. You had said that the advisory committee did not provide any notice. Apparently, they didn't provide notice to the other side as well. But there's some type of description that the advisory committee for the estate attempted to contact Mr. Grant and his mother 5 times. Did that occur or not occur?
Justice Wise, if by Mr. Gunnan sending a text message to, or 2 text messages to Grant, yes, I think that's the case. Did that identify any requirement of a response or a hearing date or when it would be heard? No, it did not.
Was he still a minor when those, over here, sorry, was he still a minor when those text messages were sent? The notice you just referred to, the text messages.
Justice McCool, no, he was not. He had been 19 for all of about 6 weeks, and he was in college living in a dorm room at Belmont University.
Your time is up. Thank you very much.
Thank you.
All right, ladies and gentlemen, we are going to go into recess before our next argument. I wanted to just take a moment to recognize Mr. J.D. Snoddy, who's the clerk of Winston County. We appreciate you being here today, Mr. Snoddy. And all of our students up here that are watching today, we're glad that you're here and experiencing oral arguments in front of the Supreme Court. So we will stand adjourned.
All rise. The court is adjourned.